Hello, today I will lecture on Chapter 7, Criminal Law. First, I would like to distinguish the difference between a civil case and a criminal case. Civil law concerns the rights and liabilities between private parties, and criminal law concerns those activities that society has outlawed. Now I will talk about some terminology we need to know with respect to criminal law. First, the prosecution. Only the government can prosecute a crime and punish someone by sending him or her to prison, and the prosecutor is the attorney prosecuting the case. The burden of proof is the standard within which a case needs to be proven. Because the penalties for conviction in a criminal case are so serious, the government has to prove its case beyond a reasonable doubt. That's the standard in a criminal case, as opposed to the burden of proof in a civil case, which is preponderance of the evidence, meaning more likely than not. Felony or misdemeanor. A felony is a serious crime for which the defendant can be sentenced to 1 year or more in prison, and a misdemeanor is a less serious crime, often punishable by a year or less in county jail. Next, I will talk briefly about criminal procedure. In the prosecution's case against the defendant, the prosecution must show that the defendant's alleged activity is indeed illegal, and then the burden of proof is where the jury must believe beyond a reasonable doubt in order to convict. This is to protect innocent defendants from undeserved punishment, allegedly. In the criminal case, criminal intent or state of mind must be proven. So the text talks about voluntary acts. A defendant is not guilty of a crime if he or she was forced to commit it. In other words, he or she is not guilty if they act under duress. Entrapment means if the government induces a defendant to break the law, they must prove that the defendant was predisposed to commit the crime. And conspiracy, if the police discover a plot to commit a crime, they can arrest the defendants before any harm is done. Now I'll talk some about the criminal process. Gathering evidence. The Fourth Amendment prohibits the government from making illegal search and seizures of individuals, corporations, partnerships, and other organizations. As a general rule, the police must obtain a warrant before conducting a search. A warrant, if a search is needed, police take an affidavit, which is a sworn written statement from an informant, to a judge who issues a warrant giving permission to search a particular place looking for particular evidence. Probable cause. Based on the information given, it is likely that the specified evidence will be found. An arrest warrant is issued based on information found in the search, and the judge may issue an arrest warrant. An arrest is when a suspect is arrested. He is informed of his rights and booked, where their name, photograph, fingerprints are recorded along with the charges. Other terminology you'll see in the text: self-incrimination. The prosecution may not use coercion to force a confession from a suspect. The suspect may refuse to answer any questions that could be used to convict him. Other terms in the chapter are trial and appeal. If no plea bargain is reached, the case goes to trial. A prosecution must convince the jury beyond a reasonable doubt in order to convict, and convicted defendants may appeal. Double jeopardy is the prohibition against double jeopardy. Means that a defendant may be prosecuted only once for a particular offense. And the Eighth Amendment prohibits cruel and unusual punishment. So let's talk a little about the Fourth Amendment of the United States Constitution, which prohibits illegal search and seizures. There are 7 situations in a police may search without a warrant, according to the text. 1, when evidence is in plain view, where they can see it, where the evidence is not concealed. 2, stop and frisk means police may search a suspect if there's good reason to believe he may be armed. Emergencies, such as a chase, a suspect may be searched. Automobiles, if lawfully stopped for another reason and evidence is visible, the police may search the entire car. Lawful arrest, anyone arrested may be searched. Consent, if consent is given by the lawful occupant of a home, police may come in and search it. And there are certain situations where there's no expectation at all of privacy, where police have the right to search any area in which a defendant does not have a reasonable expectation of privacy. A search with a warrant is unlawful if there was no probable cause, the warrant did not specify place or items, and it extended beyond the scope of the warrant. And you'll see that all in the textbook. It also talks about the exclusionary rule. Evidence obtained illegally, meaning without a warrant or an improperly obtained warrant, may not be used at trial against the victim of the search. And the purpose of this exclusionary rule is to make sure that the police follow proper procedures when conducting a search, so our rights are protected, our procedural rights. Next, we'll talk about the Fifth Amendment in the United States Constitution. It provides for due process, which are procedures to ensure fairness must be followed. Double jeopardy, as we just talked about. A defendant may only be tried once for a particular offense, no matter what is found later. Self-incrimination, the prosecution may not use coercion to force a confession from a suspect. The suspect may refuse to answer questions that could be used to convict them. And Miranda rights. When arresting a suspect, the police must inform the person arrested that they have the right to remain silent, that anything that they say can be used against them, and they have a right to an attorney, or one will be appointed for them if they can't afford one. Other amendments that affect our criminal law chapter. The Sixth Amendment guarantees the right to a lawyer and to have the lawyer present for all important stages of the process. You'll see that again. The government must provide a lawyer at no charge for those who cannot afford one. The Eighth Amendment prohibits cruel and unusual punishment. Capital punishment has been controversial under this amendment. And three strikes laws have created situations where a punishment is excessive for the crime. And forfeiture, meaning forced loss of property, has been allowed under this amendment, but the allowable amount has not been set. Crimes that harm business, why would we study criminal law in a business law class? Well, these are terms that you'd want to know. Larceny is the trespassory taking of personal property with the intent to steal. Okay, so where someone else originally had property, and then the person taking this personal property is committing larceny, right? The trespassory taking a personal property with intent to steal it. So you're trespassing and taking property that does not belong to you. Fraud is deception for the purpose of taking money or property from someone, and fraud includes bank fraud, wire and mail fraud, insurance fraud, internet fraud, and identity fraud. Identity theft. Another crime that affects business is arson, using fire or explosives to damage or destroy property, usually with malicious or fraudulent intent. And an example of that is insurance fraud, burning down your own building, your business, but we know as a policy consideration that causes higher premiums for us all. Embezzlement, fraudulent conversion of someone else's property already in the defendant's possession. Defendants already had possession, but not ownership or control of the property, and then they take the property for their own when they have it in their possession. Even though it doesn't belong to them, they take it. And defendant uses property for their own use. Hacking is a crime, the gaining of unauthorized access to computer systems, and that's discussed in the text as well. Crimes committed by businesses, if someone commits a crime within the scope of their employment, And to benefit the corporation or the company is liable, such as making false statements. It's illegal to make false statements or engage in a cover-up during any dealings with the United States government. And there's a list in the PowerPoint. You'll want to look at those too. OSHA violations, racketeering, Corrupt Organizations Act, organized crime, and so forth. So that's just the gist of the criminal law chapter. I'll upload some supplemental videos so you can get more information in depth or further complement the text chapter.